Bom dia a todos e todas. Só estou aqui para abrir o evento, sou muito feliz por essa mesa organizada pelo Felipe. Nós vamos receber aqui o professor Chander, que o Felipe vai apresentar mais. Só vim aqui para dizer bem-vindo ao professor em nome da OAB do Rio de Janeiro. Hi, professor. We're so glad you stay here with us, and I want to say we thank very much for accepting our invitation to in name of the Rio de Janeiro Bar Association, and thanks so much for your time with us, and it's an honor you stay here with us and today to discuss your very important work, and we're so glad about that. Thank you, and Felipe, you have the floor now. Start.
Obrigado, Estela. Bom dia a todos. Professor Chander, it is so wonderful to have you here with us. I'm pretty sure that even though you're not physically here, we are all together in thoughts. Before anything, just like my dear friend Stella said, I'd like to thank you once again from the bottom of my heart for your presence. We were all looking forward to hearing you, and we're really glad that you could make it. We know that these days have been crazy for everyone since this pandemic, at least here in Brazil, is taking much, much longer than we could have ever expected. If that's not a problem, I just would like to say a few words in Portuguese just to greet our public and tell them about your bio for those who don't know you yet, even though I'm sure those who have read my texts and are my students, they have known you, of course, because I always recommend you. So, então, pessoal, é uma alegria muito grande para mim receber aqui hoje o professor Anupan Chander, que é, na minha opinião, uma das maiores autoridades no mundo quando o assunto é direito e tecnologia. Lendo muito rapidamente o seu currículo, que é muito vasto, ele é professor de Direito da Universidade de Georgetown, nos Estados Unidos, é autor do livro The Electronic Silk Road, publicado pela Yale University Press, e especialista em regulação global de novas tecnologias. Com formação em Harvard e Yale, ele tem experiência no judiciário, tendo sido assessor do Chief Judge John Newman e do Judge William Norris, respectivamente do 2º e do 9º circuitos. Advogou em Nova York e em Hong Kong com Cleary Gottlieb. Foi professor visitante de Direito em Yale, Chicago, Stanford, Cornell e Tsinghua. Recebeu o Google Research Awards e uma bolsa Andrew Mellon em vigilância, tendo atuado ainda como consultor do Banco Mundial, do Fórum Econômico Mundial e da UNCTAD, sendo membro do American Law Institute. Não preciso dizer mais nada. Como que vai ser a nossa dinâmica? O professor Chander vai fazer uma apresentação inicial de 30 minutos e depois nós vamos abrir para perguntas e respostas. Eu já recebi várias perguntas ao longo dessa semana, então se vocês tiverem mais perguntas, é só comentar aqui no chat, de preferência em inglês. Professor, I was just telling them how our conversation will work. We'll start with your presentation. Please feel free to spend as much time as you'd like, and then we'll move to Q&A, which the students have been sending ever since we announced this event. You have our undivided attention. Thank you.
Thank you very much, Felipe. I am honored to have the opportunity to talk to lawyers and students in Rio. Rio is one of my favorite cities in the world. It is one of the world's most beautiful cities, certainly one of the most beautiful cities I've ever had the pleasure of visiting. And I've visited a number of times with my wife. It's just amazing. We both love it. So I'm sorry that this can't be in person, but I'm delighted to have the opportunity to talk to you all. And I speak a little bit of Spanish, so I actually caught the treinta and the preguntas, and so there's enough that I could kind of piece together from your Portuguese that I gathered what you were saying. Okay, so I'm going to talk a little bit about some of my early work and tell you about a book I'm working on. So this gives you a preview of this book I'm currently writing. Felipe was kind enough to mention an earlier book that I wrote called The Electronic Silk Road. That book is available for free online. So the one thing I negotiated with Yale was not the royalties, not the advance, but the opportunity to publish it for free online. And so you can download it in full PDF, as easy as possible online. So just Google the Electronic Silk Road, and Georgetown Commons, I think, is the easiest place to get it. So in any case, let me tell you a little bit about what I'm working on. And I'm going to share some slides. Okay, so the book is going to be called The Operating System of Humanity, Law and the Invention of the Future. So in February 1993, the newly elected President of the United States appeared on the Google campus. This is only a month into his term. He spoke at Google. This was a visit, of course, not to a company called Google, but to the physical location where Google would come to occupy a decade later. Google, of course, was only founded in 1998, largely because of the actions of the United States government. So in February 1993, he stands on the campus that would become later Google. At that time, it is a company called Silicon Graphics. And he declares, to keep the United States on the cutting edge, my job as president is to adjust America so we can win in the 21st century. This, he says, again, at a space that would later become the headquarters for Google. And so one of the questions I ask in this book is, why did the United States come to dominate the global internet? After all, the internet is supposed to make everyone equal. You can found a company and offer services from anywhere in the world. It doesn't matter where you are. You could do it from Santiago. You can do it from Zimbabwe. You can do it anywhere. So why is it that there's such a disproportionate concentration of internet enterprises in the United States? The conventional explanations go as follows. The United States invented the internet, so it's not a surprise that the US would come to dominate. We have both world-class universities and an enormous amount of capital. And this creates what scholars have referred to as an agglomeration economy, which creates a virtuous cycle where universities and capital contribute to innovation. A legal explanation is offered as well, and this is for the lawyers, all you budding lawyers and the lawyers here. Covenants not to compete are not enforceable in California, enabling employee mobility. That is, you can leave your employer and start a new firm, competing directly with your old firm. That's true in California. There's no constraints on that. There are trade secret rules, but those are the only constraints to that movement. You can't stop the employee herself from competing with the former employer. Those are all part of the truth, but I don't think they're the whole truth. Why? The US invented the internet, but Europe invented the web. So the key innovation in the internet, which has existed since the 60s and 70s, was done at the start of the 1990s by a British mathematician working in Europe for a European particle physics lab. Geography, education, and money exist elsewhere. There are lots of great universities there's great universities in Rio, and there's a lot of money in Rio. And there's especially both money and universities in Sao Paulo, huge concentrations of that in Sao Paulo, for example. And this is true in many other jurisdictions across the world. So it's not exclusively the concentration of both education and money that seems to be driving this. And covenants not to compete. Well, it turns out covenants not to compete are enforceable in Washington state. And when you think about a company like, say, Microsoft or Amazon, those are based in Washington state, not in not in California, which prohibits covenants not to compete, the enforceability of covenants not to compete. And many of the top founders didn't leave competition at all. I argue instead, in a paper called How Law Made Silicon Valley, that Silicon Valley's success in the internet era was due to key substantive reforms to American copyright and tort law that dramatically reduced the risks faced by Silicon Valley's new breed of global traders. The US served as a kind of export processing zone for digital enterprises. This solicitude was not accidental. It was rather a kind of cobbled industrial policy favoring internet entrepreneurs, undergirded by commitment to free expression. This is why I began my talk this morning with a reference to Bill Clinton a month into his presidency. He wanted to win the 21st century, and he set out to do so. What were the problems that Clinton and others were worried about? Well, so take a handful. By offering platforms for users across the world, internet enterprises faced the hazard that some users would use those platforms in ways that violated the law, bringing with it the possibility of liability for aiding and abetting. If you give someone tools, they will inevitably use those tools to do something bad. So the question is, what is the liability of the tool provider? Yahoo might be liable if someone used Yahoo Finance to circulate a false rumor about a public company, which happened all the time on Yahoo Finance bulletin boards. Match.com, a dating service, would be liable if a conniving user posted defamatory information about another individual, which also unfortunately happens all the time because people are awful. Some people are awful, most people are good. Craigslist, a free listing service for anything that you might want to sell or offer, might be liable under fair housing statutes because a landlord might put up a listing stating that he preferred to rent to people of a particular race or religion or gender. That would happen. And the question is whether or not Craigslist would be liable for those improper listings. And in this pandemic age, the last risk might be particularly relevant. Since we've come to rely upon e-commerce in particular, Amazon or Yelp might be liable for, and here Amazon the company, and I apologize, and I know how disrespectful it is to speak of Amazon in Brazil using this term that has been exploited by this American company. So I apologize for that. So might be liable for defamatory comments written by a few of their legions of reviewers. Okay. Okay. So those are the risks that they faced. And Congress set to work. In the 1990s, you saw the Communications Decency Act of 1996, which included Section 230, which has been much discussed in American media over the last couple of years, and I'll describe it shortly. There was an Internet Tax Freedom Act. There was a Children's Online Privacy Protection Act, the Digital Millennium Copyright Act, the Anti-Cybersquatting Consumer Protection Act, and e-sign, promoting electronic signatures and records. That in the last handful of years of the last millennium, paving the way for the 21st century. And to pull out three aspects of that architecture in particular, Section 230, the DMCA Title II, and limited privacy rules. And I'll talk about them shortly. And the mandate here from the Clinton-Gore administration was let 1,000 websites bloom. And this mandate from the executive was met with a similar approach from the Supreme Court, which cited the vast democratic forums of the internet. Section 230, which provides the immunities that would protect all the companies that I described earlier in the slide called platform risks. Those against defamation, against violation of fair housing statutes, against liabilities for aiding and abetting because someone defamed someone else, etc. The DMCA Title II would provide specialized protections against copyright infringement liability. These would be for the internet service providers that provide you the internet to your house. They wouldn't be liable because you were downloading something that was copyright infringing. Second, the companies that made temporary copies to speed delivery of the internet to your house. Third, and this is the most important one, the companies that hosted material online. Companies that would, that like YouTube, that had not yet been formed. And fourth, internet search engines, which would be, the Google was formed exactly this same year as the DMCA was established. And in fact, the last two safe harbors are so critical to Silicon Valley enterprises. Ed Lee, a scholar in the United States, writes, virtually all commercial websites in the US that deal with third-party content attempt to follow and fall within the safe harbors. It would be foolish, if not a breach of corporate fiduciary duty, for any company not to do so. Now, the courts also came to the rescue. Take the example of Google image search. Google image search was introduced by Google in 2001. And what this meant is that Google now would copy all the photos, all the illustrations, all the pictures on the internet and give you a thumbnail, a tiny version of those images. It would even link to the original and maybe do some inline linking of that as well. When challenged in court as massive copyright infringement, this courts held that this was fair use, a very flexible standard that has been a lifeline to technology companies again and again. You saw Google winning a fair use battle against Oracle just earlier this month in a 6-2 decision by the Supreme Court involving the re-implementation by Google of APIs, application processing interfaces, application programming interfaces, that were originally created by Oracle's predecessor, Sun Microsystems, for the Java computer language. So fair use has been a very expansive very expansive doctrine that has allowed for new technologies, new uses of copyrighted materials to be protected by law. Image search has a really funny history, and so I'll pause to mention it. So Larry Page and Sergey Brin noted that after the 2000 Grammy Awards, people were searching for Jennifer Lopez. And they didn't want just facts and bios of Jennifer Lopez. They wanted to see the dress she wore to the Grammys. And so they weren't interested in just her Wikipedia page, etc., or her discography or movies. They wanted to see her pictures. And so Google image search was born as a result of that fact. Now, go back to Amazon and its liability and Section 230 that I mentioned earlier. So in this, early on, Amazon faced a lawsuit. Mr. Schneider said, I am being defamed by someone who is reviewing my book. I think the complaint is this. I think this is this kind of complaint. The author was recently convicted of defrauding the US government. Okay. Probably it's not a good idea to follow the advice in this book. That's what the reviewer claims. Jerome Schneider sent a note to Amazon saying this is defamatory and you have to take it down. Amazon said, we're not taking it down. Okay. So Mr. Schneider sued. The Washington State Appeals Court sided with Amazon, holding that he was protected by Section 230. Amazon did not have an obligation to evaluate whether or not this was true and remove it if it determined it wasn't. So Section 230 protected Amazon in hosting literally millions upon millions of user reviews without having to fact check them, even fact check them when notified by someone who is irritated with them. I should note, Mr. Schneider still to this day only has one review of this book. So what we also know is that Mr. Schneider has no friends. All right, let's turn then to the rest of the world. What's happening elsewhere? And this is one of my really favorite cases. For those of you who've traveled in continental Europe, you know that sometimes it can be very hard to get free Wi-Fi. Why is that? Well, it's because of copyright law. Because when you're using free Wi-Fi, you might use it to download copyright infringing material. And the free Wi-Fi provider might be potentially worried about the copyright risk, the liability exposure that it has in providing that service to someone who uses it to infringe someone else's copyright. This was the case in this German decision that I'm going to talk about. Mr. McFadden operated a company. At this company, he decided to offer free Wi-Fi. And the Wi-Fi network was called Freiheitsstadt-Angst. I just love how German sounds. Freedom instead of fear. Okay, that was the and I apologize for mispronunciation. I don't speak German, but it's amazing language. Freedom instead of fear was Mr. McFadden's website, free Wi-Fi network. And this led to litigation. And the litigation was around whether or not this could potentially expose Mr. McFadden to copyright infringement liability. There wasn't any allegation that there was actual copyright infringement using his service. That wasn't the allegation. But he offered free Wi-Fi, and someone could use that Wi-Fi to download MP3s to their heart's content. And Mr. McFadden wouldn't stop them. And he wouldn't even know. The highest European court, the Court of Justice of the European Union, in 2016 said, a provider could potentially be liable for making Wi-Fi available to the public because it wasn't password protected. So there was no way to know who was using that Wi-Fi to download the illicit material. Okay, so in the United States, you can get free Wi-Fi nearly anywhere. and Starbucks is one of my favorite places to get Wi-Fi, and there's really no questions asked. You are asked for a email, but you can put in any email you want. It doesn't matter. I put in a junk email address, etc. But there's no obligation for the email provider to verify your credentials or anything along those lines. Okay, now let's turn to Japan. So early on, in the early 2000s, a University of Tokyo programmer named Isamu Kaneko offered a peer-to-peer file sharing service. And a file sharing service, by its very nature, allows you to share files. And in this case, it allowed you to share the files anonymously. And it was a very efficient service. And you could use it to share copyright infringing material, including movies. And so the police charged a person with downloading one called Unbreakable and one A Beautiful Mind. Both terrific movies, by the way, and really well worth it to not to download illicitly, but to watch. And the person was convicted, and he used Mr. Kaneko's P2P file sharing service to do so. A few months later, the police arrested Mr. Kaneko. Why? Because he continued offering his P2P file sharing service, even though he now clearly knew that it was used for copyright infringement. How did he know? Well, these two people this person had just been convicted of using his service to do this. Okay, so Mr. Kaneko spent the rest of the first decade of the millennium fighting his case in the courts. He was ultimately cleared by the Supreme Court of Japan. But by this time, it was 2010 when he was cleared. And so at this time, there's a great quote that I love from a Japanese computer scientist. He says, "I tell my students, release your software overseas." So you've got Bill Clinton on one side saying, we want to win the 21st century. And you've got Europeans and Japanese worried about copyright infringement, which certainly was happening. Absolutely. And Mr. Kaneko's service did allow for copyright infringement and might well have been used a lot for copyright infringement. But it was also a very powerful data sharing technology. So the question is, what is the appropriate system in rules for that problem? And with all this, a new business model emerges. By the end of the 20th century, laws conducive to the business model that would come to be known as Web 2.0 were in place. Companies would offer platforms in which users would provide content, which would in turn attract other users because of network effects. Companies would monetize those ever-increasing numbers of users by exploiting the personal information about them for marketing. It would sell ads that were personalized, therefore attracting a higher rate for those ads. And the law would abide this. And this would lead to a variety of benefits. So the World Bank calls this digital dividends. You might look at online shopping, which allows greater price transparency, empowers consumers and businesses. And now we think of Wi-Fi as a human necessity, almost as important as battery power. But there's enormous problems at the same time. So that model is clearly not enough. And we need to think about the future. And so I'll raise a few, I think I'll stop here and just note that there's enormous problems that we face that we need to think about how to regulate for the future. So it's been an incredible ride, and it's produced lots of incredible things, but it does leave room for us to think about for the future. I will stop here and take questions. Oh, by the way, I should say, sorry about this. It's my dog here who is sometimes making some noises, so I apologize.
He's more than welcome. We're so glad. I just can't thank you enough. The chat here has been exploding. Everybody is sending a lot of questions and congratulating you on your conference. Well, mind-blowing. For those who have read your texts, that's not a surprise, of course. You have really inspired us here in Brazil, and opening this event with you, it really means a lot to us. On behalf of our committee and our bar association, I can only thank you for your generosity and kindness. We are privileged to have heard the first considerations about your new book, and we are looking forward to reading it. This debate you brought us is really important here in Brazil as well. Platforms liability is a huge issue here, especially due to the protection that our Internet Bill of Rights brings to the platforms. They are not liable until judicial notice. Our system is not notice and take down. Of course, there are some exceptions when nudity is involved, for example, but we have a judicial notice and take down. I recently wrote about racial discrimination in dating apps, for example. And the main goal of this event we are beginning right now is to talk about diversity, about racial discrimination. And here comes the first question I'd like to ask you. Should platforms act upon discrimination? Internet is not a free land, a land without a law. If you benefit, shouldn't you be liable?
Those are all incredibly important points and questions. And the judicial notice question is a fascinating one. And so Brazil has been a leader in a kind of a breath of fresh air. So I agree, the internet should not be a lawless land. The internet should be a land of laws. And internet platforms should respect the local laws of the jurisdictions in which they operate. That should be unnecessary to say. We're lawyers. That's obvious. It's clear. Just you can't say I don't abide by the law because I'm somewhere else. That doesn't make any sense, right? So I found it. So there was an early case when Google said we can't give you the information, it's stored in California, and a Brazilian judge said that is not acceptable. And so, but here's the weird thing that has made all of this complicated. Sometimes you can have a clash between two laws. If the information is stored in California, actually Google's not allowed to share it with a foreign government without going through the various processes, and this is the MLAT process, the Mutual Legal Assistance Treaty process. There is another alternative process of sharing that information, but that's been not been used as widely as it should be. With respect to discrimination, which is obviously a focal point of this, I think that is a huge question. How do you try to ensure that the platforms don't replicate the discrimination or worsen the discrimination, right? Both. And so figuring that out is hard. I think often for dating platforms, for example, how much of it is done by users and how much should platforms intervene to try to make sure that their algorithms aren't, only pushing, certain races, etc. I think that there has to be intervention at the algorithmic level to try to disrupt the discrimination in society. And I think that companies should see that as their mandate. It's not just to replicate society, do whatever a user wants. It's also to improve society, to actually make the world a better place. And I think that's critical. Harder questions arise when there's discrimination that happens because of the use of the app. How should the app provider, what's the liability of the app provider for that discrimination by the users? So there's the algorithmic amplification question, which perhaps you can say that is something that the algorithm should be, the algorithm designer should be, should be checking, auditing, and intervening in. And then there's the question of how it's used. Someone only swipes right on people of a certain race, etc. And do we now know that Joe only swipes right on X kind of person? And then are we liable because Joe only swipes? So those are interesting questions, and I think we have to work hard as a society to figure out what are the responsibilities of the tool providers. Now, here, these aren't normal tool providers. Okay, this isn't someone who just hands you a hammer. This is someone who can also monitor the use of that hammer. Okay, who can, so this is a little bit different of a kind of set of tools than we normally have. So we could ask more, and I think we should ask more. And the companies that are involved here are often rushing to market. Their goal is scale, and without thinking through the various ways that the technology might be used or might have a particular tendency that might be problematic.
Thank you so much for this answer. You've been to the point. Platforms should also act upon discrimination. Basically, we can talk about design. How they design their filters. That's something that we also discuss. Personally, I must say that when I read your article, The Racist Algorithm, you changed the perspective of my dissertation, which then led to my book. I'm really proud to talk about this because you really changed its course. I'm happy and honored to say that many people got to know you better after this book was published. And I always recommend this paper of yours because if it had changed my mind, I wanted people to get to know you as well. Explanation is really a limited solution to the huge problem we are facing with artificial intelligence and algorithms. I love something that you wrote, which is the ultimate black box is the human mind. That is so meaningful because we tend to say that algorithms are the ones to blame, but technology means no harm. They are not biased, we are. So we must never forget that, as Jack Balkin stated, our real interactions are not with AI, but actually with those who deploy and benefit from these tools. Another problem here in Brazil is that we are narrow-minded. People think that transparency will solve any problem, but as you pointed out so accurately, please allow me to quote you. The problem is not the black box, which is often more neutral than the human decision maker it replaces, but the real world on which it operates. We must design our algorithms for a world permeated with the legacy of discrimination past and the reality of discriminations present. Wow, that's it. What else could be said? Affirmative action is something that works here in Brazil. I'm proud to say that the university where I've been studying ever since I was an undergraduate, Rio de Janeiro State University, it has been a pioneer in Brazil for that matter, over 2 decades. Many people have benefited from that. So affirmative action is something that we got used to see. But here comes my first question, my second question actually. Could you give us a concrete example of how this algorithm affirmative actions would take place?
So I think those are incredibly important questions about how we design our algorithm. We can't see the algorithm designer as simply, oh, all I have to do is fit an algorithm that does whatever people want, etc. There has to be a sense of responsibility about how the algorithm is trained and how the algorithm is used. And so I think there has to be interventions at both times. Here's an example which is interesting, but not entirely ideal. Okay, so let me give you an example. Amazon fed an AI with the resumes of its current employees, and it said, tried to figure out so that you could feed it new applicants, so they could see, are they going to be a good Amazon employee or not? And it turned out that Amazon realized that the AI was favoring men. It was systematically biased against women. And what Amazon did was it said, we're not using the algorithm. I don't know what the solution was. Okay, that's at least a solution. It's not, that isn't a solution that improved the AI to solve the problem. But you have to do these kinds of audits, and you can't just say, I fed it neutral data, and therefore it's now going to produce a neutral result. That's just not, in a world where we are full of prejudice, of generations past and generations present. Those are, we can't imagine neutrality in algorithms that take data points from that existing world. And so I think I think it's a fundamental problem, and I think it's one that we have to keep on working on. And I think algorithm designers have a responsibility to think about that and to intervene. And one of the weird things about this, and as you know from my paper, is that means that the algorithm designers have to ask about race, have to ask about gender, maybe in other contexts have to ask about income and things like that, which might seem like exactly the wrong questions, but that's the only way to figure out if the other variables that they're asking are not actually proxies for those variables that might more clearly show discrimination. And so in order to audit the system, you have to know actually a lot. And so you have to have rules that allow for that kind of information gathering. So it's actually really kind of to figure out whether or not the discrimination is going on. And I realized this because early on in California, about 15 years ago, people who were against affirmative action tried to pass by initiative an amendment to the Constitution that was called the Racial Blindness Initiative. It would have prevented the government from asking about your race. Very clever, okay? So they're like, the government should treat everyone the same. It should not ask anyone about the race. But the whole point was to stop affirmative action, because if you can't ask about race, you can't figure out that you're discriminating. You can't intervene. You can't collect statistics that show, hey, look, we're just not hiring people of this race. So it was very, very clever. And so that lesson has stuck with me, that brilliance of that move. Luckily, it failed. Luckily, thank goodness that the California people saw through it. But anyway, it's a reminder that it does mean collecting uncomfortable information. As long as it's used for legitimate things. Now, you can use that uncomfortable information for terrible things. So this is a tricky area.
Wow, thank you so much. I have a final question. I know that you have an appointment shortly. So here in Brazil, we have in our Brazilian General Data Protection Law, our LGPD, which has been deeply inspired by the European GDPR, a right to review and get explanation from automated decisions. Of course, that there is a limit here for trade secrecy matters. But contrary to the GDPR, this review is not a human review. Actually, in the beginning, the bill clearly stated that, but our president, under a lot of pressure from legal techs, fintechs, decided to use his veto power, and we no longer have this provision, even though some people, me included, we argue that we can extract this right from other sources. Our law was so good, it even paid attention to the size of the company. But anyway, my question is it truly important to have humans reviewing these automated decisions? Is that a fundamental right? Could you say that?
It's a great question. So I think it depends. So for example, let's imagine, so I always think about things that open and close doors. Okay, so we can imagine an AI that's kind of learned when you want to open or close a door. And you just wave your hand or something, and the AI has figured out this means that the person wants to open or close the door. I think in those cases, we don't need a human review. But obviously, when you have AIs that are making important consequential decisions about you, not just a minor thing. So there's a lot of AI in our lives. For example, there's AI that is correcting our, this video right now. It's, so it's doing a lot of technical processing that, kind of, even if it didn't get this bit of my face, it's trying to, say what the bit would look like, or my voice or something like that, right? And there's AI that's enhancing my voice because I'm the current speaker, et cetera. So there's a lot going on. I think for those things, I don't think we need a human audit, a human intervention and the right to, but for decisions that have significant consequences in your life, credit decisions, employment decisions, it's an interesting question of dating decisions. I mean, that issue is a really fascinating one. But typically there hasn't been laws about dating. I mean, I love your research area. I mean, that is amazingly interesting. But we typically allow people to discriminate in their personal lives, which is really interesting. And so, so anyway, there's more to be thought about, in that context. Why do we allow that there, and not allow that in, public accommodations and employment and all those kinds of things? It's, but I think, yes, for those decisions that are meaningful in one's life, not the ordinary technical stuff that it's just, AI is being used a lot around us. Like whenever I use the PowerPoint I use, there's a Microsoft AI that I'm relying on to make it look pretty. I don't need Microsoft to explain, that to me. I don't want Microsoft to explain it to me. It's just, and what you said, Felipe, about size also matters, because you have to kind of, you don't want to regulate in a way that makes small companies impossible, because the big companies can handle a lot of regulation. Tiny companies, they can't hire a phalanx of lawyers. They can't do all the, the record keeping, et cetera. So we need to, I think, be cognizant of the fact that tiny companies can cause problems. So, so when tiny companies have enough scale in terms of the damage they can do, then I think we need to regulate closely. But I think we should, and maybe when they're in high-risk areas, when they're intervening in high-risk areas, regardless of scale, then we think we should regulate closely. But I think that we shouldn't, see, one of the worries that I have is we often regulate with Google and Facebook in mind. And the reality is the companies that are regulated, the companies that are dealing with data are just your ordinary mom and pop stores, your laundromat that's keeping a list of its clients and how they like their shirts starched, or their dresses cleaned. Do you want to use an organic compound or a non-organic compound? Do you pay, all those things. I think we want to be careful in not creating a kind of an overly regulated environment that makes it impossible for ordinary businesses to operate. And so I want to be cautious about that. And the capacity of anyone to enforce such laws is also quite limited. In the European Union, the GDPR, which, as you note, is the source of the Brazilian data protection law. I wrote a study recently for the World Bank, and I hadn't realized that they spend less than €1 per person per year in enforcement. So it's not that there's a tremendous amount of enforcement resources put in Europe as well. So sometimes the laws can be very beautiful on the books, but the practice may not be exactly as the book suggests. So it's important to write laws that are practical, that can be complied with, and don't create unnecessary burdens when there really is not much practical effect, and there's no practical possibility that anyone's going to look after the laundromat's database and evaluate exactly what's going on.
Professor, that answer was, like the other ones, brilliant. We have loads of questions here. If that's not a problem, I'd like to ask you just one more. It comes from our chat here. It's from Professor Caitlin Mulholland, which is a great expert here in Brazil, one of the greatest we have here. She said the following: Professor Chandler, do you believe that an international regulation by the way of competition agreements is the way of imposing liability to internet platforms?
So this is, a great question. And I think, so one of the difficulties that every user has is when they're especially when you're outside the United States, you're dealing with companies that are based outside. Now, Brazilians are lucky to have a robust judiciary, which demands respect. I mean, Brazil has a serious judiciary that some countries don't even think they can regulate the internet. They don't even try. Okay, so this is also a problem. So smaller countries think, oh, that's far away. No one will listen to us. We're just, subject to those whims. And I think Brazil is in a position to actually regulate. And I think that's really important. I do think that international agreements on this are important, but they're hard to obtain. In the competition area, typically competition law has been national. And so there hasn't been much internationalization of competition, competition agreements. And so right now you're seeing some movement on international tax, and I think that's important. I'm hoping that there will be more and better and more robust kind of taxation across the world, because what all companies have done is use tax havens to avoid, they've structured themselves to avoid paying taxes where they're making money. So that's, obviously a huge problem, and I think the world needs to address it. So yes, I think it would be useful. I'm not super optimistic on the competition side. So I think national authorities are still going to be the principal venue for enforcing law against internet companies and making sure that they are complying. And I think it's also important to think about what those laws should be to ensure that you have a robust innovation environment, and you don't kind of hobble yourself for no real benefit to the citizenry. And you have to think about the various benefits of being a digital society. And I think everyone is moving towards becoming a digital society in the 21st century. Our pandemic life has already kind of made that even more, that it has accelerated that process, of course. So it's an important question about it's an issue that every country in the world is facing, and the United States is trying to figure out how to regulate its internet enterprises. China is doing the same, European Union certainly, and every country in the world is faced with these questions. I do think that there's a lot of benefit from internet enterprises, and I think we should not just think of everything being terrible. There's a lot of things that are positive. So what I like to say is everything bad that happens in the world has an online component, but so does everything good that happens in the world has an online component. And sometimes we are focused on the bad things and their origins or the ways that they are amplified online, but all the good things as well. And so we should be realistic, cautious, and we should, think that regulation is critical. But we shouldn't be. The world is a disaster. We have lots of problems to face, and I think we can solve them. And I'm glad to have the opportunity to talk to students and young people who are going to be leading in that in the future.
Professor Chander, I know that you have an appointment, so on behalf of our committee, our bar association, AqualtuneLab, I can't thank you enough for your kindness. We could spend the whole day hearing you and watching Dobby as well. We are all delighted to hear from you. We really hope that you and your loved ones are doing well during this pandemic, and we all hope that we can meet in person as soon as possible. We would be really happy and honored to welcome you here once again in Brazil when this nightmare is over. For all of those who have watched this, a special thank you as well. People from all over the country and even from Germany, I've heard, are watching us, which is amazing. Just saying final words in Portuguese. Para todos aqueles que estiveram conosco até agora e que tiveram o privilégio de ouvir o nosso primeiro palestrante, fica o nosso agradecimento e o convite para a abertura oficial deste evento de 2 dias, que vai acontecer às 14 horas, aqui nessa mesma página. E um aviso final com relação às inscrições. Quem quiser ganhar certificados de participação no evento, basta fazer a sua inscrição pelo Simpla. Professor Chander, thank you once again. And that's, do you have any final considerations?
No, thank you very much. It was lovely. Thank you. Thank you, Felipe.
Thank you so much.
Okay, take care.